policing the police every single day, and doing what the Charlotte County Sun newspaper and local TV stations won't do every single day.
I'm Dave Champion. Let's talk about California that may also be representative of your state. Okay, so several days ago, Santa Clara County, the health directors told all the population, about 7 million people, that they had to stay home. And just yesterday, as I'm filming this, Gavin Newsom, the governor of California, ordered 40 million people to stay home. So what I want to investigate, what I want to share with you is, are those lawful orders? I want to present this information in 5 distinct categories. First is going to be the law. Second, what is government trying to accomplish? 3, how receptivity to these kind of videos where I talk about what the legal facts are has changed a bit in the last week or so. 4th, my personal views concerning COVID-19 and what should take place. And lastly, and perhaps most importantly, I have a message for law enforcement. Something I'm seeing a lot of buzz about, a lot of concern about on social media is that the government may declare martial law over this. There are 2 governments in the scope of this video that could declare martial law, because we're talking about California, right? So it could be California could declare martial law, or the federal government could declare martial law. Let's start with the federal government. I think a lot of Americans wrongly believe that the federal government has universal authority throughout the states of the union on virtually anything. I think that's how a lot of Americans perceive the federal government, and that is legally and constitutionally completely wrong. Unless the Constitution vests the federal government with a specific enumerated power that it can exercise within the 50 states, it can't. Can the federal government declare martial law? Well, sure. By U.S. custom, tradition, and practice over 230 some odd years of the United States existing, martial law can be imposed under the following circumstances. Society can no longer rely on government to provide the basic government services, and the courts are no longer viably operative. That is clearly not the situation here. However, let's, for the sake of argument, say that we end up there next week. The federal government can only declare martial law in federal places where it exercises what the law calls municipal authority. Okay? So it can declare martial law in Washington, D.C. It can declare martial law in Guam, the Virgin Islands, U.S. military bases, lands within the states of the Union that have been formally ceded to the United States, and so forth. There, the federal government declare martial law. Within the 50 states? No. The other thing a lot of people have been talking about in terms of the feds is that they're going to federalize, that's an official term, they're going to federalize the National Guard and call them up. I don't know whether that's true or not, I don't care, because, as I just mentioned, once they're federalized, they're the equivalent of federal employees. I just mentioned that constitutionally, statutorily, and every other legal way you can imagine, the federal government has no right to declare martial law within the states of the Union, except perhaps in the case of insurrection or rebellion, which of course this isn't. So can the governor of California declare martial law in California? Yes, it's right there in the California Constitution, provided that there is rebellion or insurrection. It's right there in the California Constitution. In the case of rebellion or insurrection, then the governor can declare martial law. So he's granted that specific authority for martial law and no other. Let's now back away from a discussion on martial law and talk about just ordinary non-craziness. Okay, does the governor, in this case we're talking about California, does Governor Newsom have the authority to do this and such under an emergency declaration? Okay, so Newsom drafted and signed an executive order several weeks ago declaring a California emergency. That gives him additional flexibility in ordering state agencies to do this and such. Okay? He has no direct command over the citizens of California. Also, individual rights are still intact, and that should be manifestly obvious to everybody, that because a bunch of people are getting sick and there's an infectious disease, people's rights don't just evaporate. As much as the scaredy cats would love that to be the case, it doesn't. Sorry, it doesn't work that way. That is illustrated in two provisions of the emergency statutes for the state of California. Number one, there can be no ammunition, no firearms, and no accessories seized during a time of emergency. And the governor does have the right to use private property, provided that the state pays the agreed upon amount. That means the state has to approach the owner and say, how much do you want for us to use that plot of land for whatever? Okay? The owner can then say, I want this much money. The state can then say, yes, we'll pay you, or no, we won't. And if we won't, we'll go look for another piece of land, or whatever the private resources are that the state would like to use. So you see the right of property, the right of having it not seized except by agreement, the right of firearms. These are examples of preservations of individual liberties. There are no individual liberties that are suspended simply because there's an emergency. I should mention, as I did in the last video, that I'm not sitting here reading out reams of law to you because I don't know what that really brings to the party. You can look it up for yourself. The parts about the authority of the governor are in the California Government Code. The chapter, I think, is something about emergencies. You can Google it. It'll come right up. And then some of the more detailed aspects I'm going to get into in a moment are found in the California Health and Welfare Code. So you can go look these things up for yourself. Please, as always, do not believe me. Look it up. On March 12th, California Governor Newsom issued a new executive order which stated, and I quote, all residents are to heed any orders and guidance of state and local public health officials, including but not limited to the imposition of social distancing measures to control the spread of COVID-19. Okay, did you hear that? Did you take that as authoritative? Okay. Let me read these first words again. All residents are to heed any orders. So the word heed means to give consideration to. You're to look at them and ponder them and consider them and decide what you think about those. That's what the word heed means. It does not mean obedience, and it sure as hell doesn't mean mandatory obedience. Under California law, in time of emergency, the governor has zero authority to isolate or quarantine anyone. Under California law, during a time of emergency, that authority is possessed by the director of county health services in each individual county in the state of California. Whoever the director of health is for that county does have the statutory authority to isolate or quarantine people, and isolate and quarantine are two separate things, which we're going to get into here in a minute. Okay, so the governor doesn't even have this authority. It makes sense that authority was vested in the counties because California is a big place. San Diego County may have completely different needs or requirements than some county up in the north end of California. So this allows the steps that are taken to be tailored to the circumstances found by the director of health in each individual county, and that, of course, makes perfect sense. Under California law, isolation pertains exclusively to those who are infected, and it grants the county health directors the authority to isolate them. But, this is going to be a repetitive theme, they must know the person is infected. There's no speculation or supposition involved in that process. They must know the person is infected. However, once they have that knowledge, they can isolate the person. Quarantine under California law, in the circumstances that we're referring to here today, quarantine is erecting boundaries and rules around people who have been exposed to the affected person. And once again, as I just mentioned, the director of health or his designees must have knowledge of that exposure. They can't just say, well, a lot of people are infected and you were out walking around today, so we're going to suppose, we're going to speculate that you have been in contact with an infected person, and so we're going to quarantine you. Doesn't work that way. They must have particularized knowledge about you if they want to quarantine you. Okay? These are all fundamental legal truths that apply to issues all across the legal spectrum in the United States and have since the founding of this nation. This is nothing new or novel. As you can see from the information we've discussed and the fact that these officials have to have particularized knowledge in order to do X or Y, and the governor doesn't have the authority that I think a lot of Californians imagine he has. And again, this applies to a lot of other states. I'm going to get to that in a minute too. So in the absence of draconian dictatorial powers, what are the states trying to do? What are these governors trying to do with these orders? They're trying to mislead people. I mean, that's the bottom line. Their thinking is, if we can mislead the public into thinking these things are mandatory, then things will be better for our state. I will leave that to you, whether that's a wise approach. My concern, of course, is if the rank and file sheep accept these falsehoods, the way government operates, the way certain people in government think, this is only laying foundation for more misleading, more lies, more mischaracterizing, and more oppression of rights in the future, because they realize that all they have to do is make a certain percentage of the population fearful, and voila, words absent authority, everybody assumes there's some lawful authority, when in fact there's not. That's my concern about misleading the public like this. And this sort of misleading of the public is not limited to Governor Newsom in the state of California. As an example, right here in California, our governor, Sisolak, he did the same thing a couple nights ago. He got on television and he gave this speech. However, his language was a little bit more transparent. He repeatedly talked about what people should do. He did not use mandatory words like must and shall, because he knew that he didn't have that authority. So when I say he knew, does Newsom know? Of course he does. Because here's what happens. They sit down in a conference room and they're all going to discuss what they're going to do, what they're going to release an executive order later today or tomorrow. The Attorney General is sitting right there. And the way that works is the governor turns to the Attorney General. He says, where's my latitude on this? And the Attorney General has already gotten out in front of that with his attorneys, and they've done the research, so he's been briefed by his staff attorneys. And so the Attorney General says to the governor, look, your authority here is limited. And so if you go on television and say you don't have much authority, it probably isn't going to attain your goal. So try and sound as authoritative as you can. Having been told about those limits, then the governors are doing the best they can to sound authoritative and commanding, and that's why they use things like order when it's not an order at all. When I first started doing these videos where I was discussing the law, and I kind of got out in front of that a little bit, I was discussing some of the possibilities before we got to this point. In response to those videos, the first ones, it was like, oh man, I'm glad to hear the truth. Yeah, that's great. Thanks, Dave. I noticed some of those comments, not all of them, a small percentage have changed. And now what I'm seeing a little bit more of is essentially the message, shut the hell up, Dave, you're not helping. Okay, so if your agenda, what you would like to see happen, is such that facts and truth must be suppressed, your agenda is crap and you need to knock it off. I get that you're afraid. And I get that knowing what the law really says, that it doesn't empower the government to the extent you may want, bugs you. That's not my problem. You have a problem. The information is not the problem. There are so many myths and falsehoods floating around there about COVID-19 that I hardly know where to start on my personal views, and I don't think I want to make this video even longer by discussing all the falsehoods and the myths that are out there. So I think I will simply say social distancing. Everyone should do it. Okay? The reason is that the COVID-19, but it is no more contagious than the ordinary seasonal flu. However, it has a couple of distinctive factors that make it spread more readily. Okay? Number one, it has up to a 14-day incubation period. So people can be walking around for 13 days. They're infected, they're contagious, but they don't know, they feel great. Okay? That is not the profile of the average seasonal flu. It does not have a 14-day incubation period. So that's one distinction. The second one is a certain percentage of people who get COVID-19 are asymptomatic or minimally symptomatic. In other words, they've gone through that incubatory period. They actually have the virus in them doing whatever it's doing in them, but it's not manifesting. And so during that time frame, those people who are asymptomatic or minimally symptomatic are out spreading it as well. That again is not like the normal seasonal flu. There are virtually no cases of people being infected with the normal seasonal flu who are asymptomatic. It's exceedingly rare. It's not exceedingly rare when it comes to COVID-19. So those are just a couple of the distinctions as to why COVID-19 is prone to more rapid propagation within the community. So that's why I support social distancing. To me, it's just like common sense. If somebody is a confirmed case or they're at home and they have what they recognize as the primary symptoms, stay home, self-quarantine, isolate yourself. Again, I mean, the fact that government officials have to say this shit as if it's law when it's not is because people are being knuckleheads. This is common sense. Social distancing is common sense. Isolating yourself, if you know you have it, is just common sense. Canceling large gatherings. Can you predict what I'm going to say? Extremely wise. Okay, so these things that the government is doing, the steps that they're taking at this moment in time, what they're suggesting is good. It's wise. It's common sense. It's what anybody who cares about themselves and other people in their community would choose to do voluntarily. The only thing I see problematic is these governors and other officials attempting to mislead people that these are legally binding orders when they're not. My message to law enforcement officers is simple. Do not, under any circumstances, allow yourself to be roped into enforcing any of these suggestions. Because these are suggestions with no legal force and effect, except for the circumstances I talked about with the county officials, if they have particularized knowledge that you are infected, or they have particularized knowledge that a person has been in close proximity to an infected person, one being isolation, the other being quarantine. Unless those officials have that particularized knowledge, which is almost unheard of, there is no legal authority. So like this order from Newsom for 40 million people to stay home. Sworn peace officers, you need to understand, it is not a lawful order. This sets up some interesting dynamics. If you allow yourself to be propelled into acting as an enforcement agent, you're on your own, buddy. You don't even have peace officer status at that point. You're acting outside and beyond the law. There is no peace officer status if you're acting outside and beyond the law. Furthermore, if you try and lay your hands on somebody, because there is no law supporting your actions, they can lawfully fight back. Of course, now you're in physical contact with the person. How helpful is that, right? During a pandemic. Let's say they begin to win the fight, right? What's the law enforcement mindset? Okay, so if this guy's going to beat me up, well, they teach this in officer survival school, right? I've taught it myself. I understand. If this guy is going to beat me up to the extent where I'm powerless, he can then take any one of my weapons and perhaps kill me and kill others. That's the law enforcement doctrine. So if it looks like the citizen or the whoever is winning the fight, the officer is authorized to increase the level of force up to and including deadly force. So officers, if you choose to try and get physical with somebody when you have no law behind you, and things escalate because that person is lawfully and correctly defending themselves against an unlawful physical attack, okay, and you end up getting shot, okay, And what's going to happen, of course, then the rest of the police department is going to presume that guy's a cop shooter or a cop killer, and they're going to go after him and probably execute him. So, cops, just enforce laws that you have absolute knowledge are valid. They actually exist in a statute, and do the job you always do, right? That's simple enough. Just don't allow power-hungry politicians or people within your command structure who are authoritarians, don't allow them to push you down the wrong road. And that's it. I've got nothing left to say. You have a great day. Bye-bye.
Hey Charlotte County, this is Charlotte County COPWATCH. I am using any video here with under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.